human rights lawyer, what I hope to talk about is how a lot of these instruments have failed us, but also how they can be used moving forward to ensure a more broader-based, thank you, a more broader-based gender equality moving forward. So, given the confluence of all these instruments and movements, and given the growing and more public use of sexual violence in conflict, I'm hoping to talk about the failings of international legal frameworks, particularly in the context of sexual violence in conflict, to talk about one, where they fell short, and two, how they could be done better. So moving forward, I hope to talk about the international legal frameworks addressing sexual violence in conflict, how precisely they fell short, how when created or now being used by lawyers, they're not being used in a sufficient way to ensure gender equality. And then I'm going to talk about how the organization I work for, the Global Justice Center, or GJC, tries to bridge those gaps. But
can you just say what your organization is again?
My organization is the Global Justice Center, or GJC. We seek to ensure global gender equality through the rule of law. So it's an organization of lawyers that strategically find opportunities to embed basic framework type foundational laws with gender equality, or use the gender equality that's already in those to then empower women all over the world. So before turning to the legal frameworks, though, I do want to talk about sexual violence in conflict as a phenomenon. And it's, for my money, the civilians are increasingly targeted in conflict, and I think that that's something that's generally recognized. And as a part of that, I think that has to do with the nature of conflict, where it used to be, geopolitical type wars, where you're having, large-scale wars like on World War I, where it's combatants fighting combatants. But more and more, it's become wars of ideologies. And with wars of ideologies, that you begin to envision the civilian or the woman and girl as a victim, or as a target. So as part of the increasing targeting of civilians, you have the increasing targeting of women's sexuality, of women's reproductive capacity, actually literally being a part of the battlefield to fight the ideological battle that we're having now. And I think sexual violence in conflict is remarkable as it is being practiced now for two reasons. One, its prevalence, and two, its lack of priority. As to the prevalence, between 250,000 and 500,000 women were raped in the Rwandan genocide. As of 2013, 50,000 women had been raped in Syria. In Bosnia, women were held in rape camps and were not allowed to go until it was too late for them to obtain an abortion. In the rural areas in Burma, girls as young as 8 report being raped by the military in those regions. That has been almost 60 years of ethnic conflict, and a campaign that's gone with wholesale impunity. And of course, in Nigeria, they say, I think, I'm not going to get the numbers quite right, but I think roughly 20 women are raped every 4 minutes. And of course, in Syria and Nigeria, ISIS and Boko Haram have been kidnapping young girls and forced prostitution, forced sexual slavery, forced marriages, forced childbearing, widespread disappearance. And so, I mean, that's an absolutely appalling characteristic of the last 20 years or so. And which is to say, of course, that the prevalence is absolutely there. But what makes the prevalence doubly troubling is the lack of priority. In addition to being International Women's Day, today actually marks the 1-year anniversary of the disappearance of the Malaysian airline flight into the Indian Ocean. And I certainly was enraptured by what was going on with that. And just on Friday, there was an article on the front page of the New York Times website talking about that the international campaign or search for the plane continues, that ships and satellites and airplanes are canvassing an area in the Indian Ocean the size of California and Texas combined in order to find wreckage of the plane, even though the passengers of the plane are presumed dead. Now, compare that effort with the disappearance of, at relatively similar time, the disappeared Nigerian girls, 390 Nigerian girls in the jungle. I can't remember the last time I saw an article on the front page of the New York Times talking specifically about that disappearance, and off the top of my head, I can't remember it. And I would be shocked to hear about any widespread multinational effort to go into the jungle and look for them the same way that effort was done for dead people in the Indian Ocean. So what are we saying about how we prioritize women and girls that are victimized by conflict-related sexual violence, who are still alive, when we are prioritizing them to dead people in the Indian Ocean? Another example I like to use talking about the low priority of sexual violence is in 2012, when the civil war in Syria was beginning to escalate and President Bashar al-Assad was suspected of using chemical weapons against his citizens. President Obama set a red line and said, if President al-Assad in fact uses chemical weapons, that is a red line that the global community cannot stand for. It would warrant international action to make sure that crime does not continue. Well, as President Obama was saying that, and as Assad was suspected, Assad's military and government-aligned militia were carrying out a systemic, organized, and very intentional campaign of rape of opposition women and girls, and that is very, very well documented. And what I think is interesting, or what I think is tragic, is the fact that that wasn't the red line. Why does it have to be chemical weapons? Why can't the very well documented cases of rape be the red line that enrages the global community to this point where we have to do something? So, taking into consideration the prevalence and the lack of priority, I want to shift now to talk about some of the international legal structures that are in place that are ostensibly designed to try to prevent, or at least deal with instances like I've been talking about. The first is international human rights law, which was largely born after World War II. It's entirely treaty-based, and it's things like the Convention to End All Forms of Discrimination Against Women. It's like the Convention for the Rights of Disabled People. It's like the Convention on the Rights of the Child. It's, there's a whole litany of them. Part of the problem with those, though, is that one, with the exception of CEDAW, ensuring a gendered perspective on how some of those, on how the terms of those treaties, or the rights created in those treaties, are carried out, the gender perspective is not always necessarily there. And another problem with the international human rights law is that in order for them to be binding, the state has to have ratified it. And like some of you may know, the United States hasn't ratified CEDAW, and so, there are other sources of rights, obviously, for women, but at that international standard, at that normative standard of making a difference for women worldwide, it's not there. So, a two-pronged problem in international human rights law of, one, only being applicable when the state has ratified it, two, not necessarily covering the gender perspective, though they are getting better, and three, which I didn't mention, the specific instance of conflict is not covered by a lot of them, well, again, with the exception of CEDAW. The next area of law that is designed to help or to address sexual violence and conflict is international criminal law, which in its modern form began after World War II in Nuremberg and Tokyo. But in those tribunals, rape wasn't its own crime. It could have been tried as a crime against humanity, but it didn't take the forefront. It wasn't in people's consciousness as something that needs to be addressed after the war. There was a shift in that a little bit in the mid-1990s with the international criminal tribunals in the former Yugoslavia and Rwanda that were actually quite good. Rape was specifically articulated as a crime that could be tried as a crime against humanity, and the jurisprudence that came from those courts established that rape could be a constituent element of genocide, that it is a form of torture, and that it was a war crime, and it was a crime against humanity. But that was relatively recently, and it was in 1996. And then moving forward, of course, with international criminal law, in 2002 you had the creation of the International Criminal Court, which really did a lot to ensure a more gendered perspective is being looked at for war crimes or crimes that happen in war. So the definition of rape that is under the statute that created the International Criminal Court is gender neutral. It accounts for any level of penetration in any orifice, which is not how the rape crimes were tried before. The way the rape crimes were tried before were antiquated, patriarchal type language that would require proof of lack of consent, or whatever the contours of local laws might be, which are obviously very problematic when trying to deal with a war situation, but also are absolutely awful as it comes from the victims or the woman's perspective. So the ICC did make some progress there, but what you might know is the jurisdiction of the ICC is somewhat limited. There have been a lot of acquittals, and the 2 convictions that they've had, neither of them were, sexual violence was not included in the convictions, even though it was a part of the original complaint. And the last area of law is the one that I focus on most primarily at the Global Justice Center, is international humanitarian law, and that, or the law of armed conflict, or otherwise referred to as the Geneva Conventions. But even those, it has taken some time in order to establish that gender crimes or gender-based violence or crimes of sexual violence in conflict need to be pushed to the forefront. And in the first Geneva Conventions, they outlawed things like degrading treatment or sorry, I'm having a blank, but otherwise degrading treatment, torture, things like that, not explicitly naming sexual violence or rape. In the 4th Geneva Convention, you do have the explicit protection of women, or the obligation to protect women from rape, and the same in the additional protocol. So rape is articulated as something that is forbidden under the Geneva Conventions, but again, it doesn't necessarily have, and these were in the 1970s and 1940s, it doesn't have the articulation of rape that the ICC did. So if those crimes are going to be tried, they're going to be tried in a very patriarchal, antiquated setting. So one thing that all those legal frameworks have in common is, I hope that it's been coming through a little bit, is a wholesale lack, or not a wholesale lack, but a definite lack of a gender perspective, of taking into consideration what the effects are on women, how conflict goes, how women are affected by conflict, how their experiences are meaningful in conflict. For the large part, and still today, conflict is very much considered men fighting men, combatants fighting combatants. And what a gendered perspective can do, it can alter that framework to present a more true reality that what armed conflict is it affects an entire society. It's more of a total war situation, particularly in the context of the more ideological wars that I was talking about in the beginning. So a more gendered perspective in how these laws are respected or enforced or created could, build more robust reparations regimes coming out of conflict. They could lower the burden of trying crimes of sexual violence in conflict. Ultimately, they could lead to more and stronger peace with the inclusion of women in the peacemaking process or in the negotiation process. But those are things that are actually only beginning to percolate out now.